Hear ye, hear ye, hear ye. The Honorable Supreme Court of Ohio is now in open session pursuant to adjournment.
It's muted. Good morning, ladies and gentlemen. Our first case this morning is 2019-1567, the State of Ohio versus Andrew Fausenbacher. For the appellant, Ms. Corrigan.
Yes, thank you, Your Honor. Chief Justice O'Connor, and may it please the court, good morning. I'm Jacqueline Corrigan on behalf of the State of Ohio, and I would like to reserve 5 minutes of my time for rebuttal. And I'm hoping everyone can hear me. Because the question for this court this morning is, how shall we determine when something is an unoccupied structure for the purposes of our criminal code? Currently, the statutes do not specifically define that term. It's only defined sort of in the absence of being an occupied structure. Now, the state proposes that the logical analytical structure to determine when a structure, for lack of a better term, is an unoccupied or an occupied structure is to first determine under Revised Code Section 290901C whether the something that we have before us fits into any of the 12 categories of things that the law will protect. And if it does, then it's a structure that the legislature intended for the law to protect and to prescribe certain kinds of conduct in those structures. But then moving on, if that structure falls into any 4 additional categories or circumstances apply to it, that structure can be considered occupied. For instance, for the statutes prescribing burglary versus breaking and entering, like we have in Mr. Fausenbacher's case. And if the structure doesn't fit into the definition of an occupied structure, then logically it must be unoccupied. And this is the logical framework that makes sense and fits into the legislature's intent to punish conduct like Mr. Fausenbacher's. And what the state is asking this court to do is to make that logical framework explicit for the rest of the courts of the state of Ohio. Because what we currently have is we have at least a couple of different approaches to determining whether a structure is unoccupied. And one of those is roughly the structure I just described. That's the one that many of the courts of appeals have applied when they've faced a question like the one we have in Mr. Fausenbacher's case. But then the Ninth District had determined in this particular case that if a structure is not an occupied structure, it cannot be an unoccupied structure. And in Mr. Fausenbacher's case, reversed his breaking and entering conviction on that basis. So without a clear analytical framework prescribed by this court, the state argues that the legislature's intent to punish conduct like Mr. Fausenbacher's and even to punish arson as opposed to aggravated arson would go unfulfilled. So that's the framework that the state is asking this court to adopt. Now, just to review.
So you mentioned the purpose of the General Assembly, the purpose of the legislature. What do you think that purpose is? I mean, what's the purpose behind distinguishing between an occupied structure and an unoccupied structure? Is it to protect anybody who might be living inside, or is it to protect structures that might be used as a home, even a temporary home? What do you think the purpose is?
Well, to address the purpose of protecting unoccupied structures first, the legislature has clearly decided that it wants to protect people's property in addition to protecting people. Now, in protecting occupied structures and making conduct in occupied structures punishable by longer terms in prison, for instance, it's the legislature's acknowledgement that when people are likely to be present in a structure, there is, like you said, a higher risk that people will be harmed. And so that is evidence of the legislature's intent to protect people more than just property.
Well, if that's the reason for the distinction, doesn't that cut against the state? I mean, if what the legislature is trying to get at is a distinction between whether people are there or could be there, here you've got a travel trailer covered, parked in a storage facility. So how would that fulfill the goal of trying to protect places where people might be living?
Well, that's why the legislature set out in the breaking and entering statute that they're prescribing conduct in unoccupied structures. And it's an acknowledgement that the legislature not only wants to protect people and protect places where people might be, but also to protect their property. And that's why that's important. Because, for instance, in a camper like we have here, even though it was parked in a storage facility, which would tend to indicate that people weren't likely to be there at that moment, that it was still a very valuable piece of property. And for instance, the legislature also has included in the definition of what would be a structure under 290901C, they protect tents, trailers, railroad cars. A railroad car is not always something that a person would be present in, but it obviously is something that the legislature intended to protect. It protects vehicles, shelters, or even any portion of a shelter, or the catch-all of other structures. So I think the distinction between unoccupied and occupied is a recognition that the legislature wants to protect property and people, but it has a heightened interest in protecting individuals. And I hope that answers Your Honor's question. Otherwise, in this case, getting down to the camper, I think that one of the things that we would have to look at is that this camper could arguably have, under some circumstances, been an occupied structure. But even going back to the Carroll case, which is one of the decisions that the Ninth District based its opinion on, the Carroll case involved a Volkswagen microbus. And in that case, this court had determined that the microbus was a motor vehicle and it wasn't an unoccupied structure that the law would protect. The Ninth, I would argue, imperfectly understood Carroll, and that campers like the vehicle that we have in this case would be an other structure under 290901C, and then we would determine whether it was occupied or unoccupied. But the state argues that the analytical structure it has just proposed is logical. It follows the framework that already exists in the statute. Clearly, if something is occupied, it cannot be unoccupied, and vice versa. And I think that's the only problem that we have with the statute, is there is no definition set out by the legislature of unoccupied. But clearly, because it's one or the other, occupied or unoccupied, the legislature was essentially defining the term unoccupied only in the absence of occupation. And so because occupied and unoccupied modify the term structure, then this framework that the state is proposing today is logical. It adheres to the legislature's intent, and It also avoids absurdity, which is arguably what we could have in this case and in other cases. For instance, there was a case in the second district at State versus Johnson where the court overturned a burglary, or not a burglary, but a breaking and entering conviction. The structure that had been broken into actually fell into more of the definition of an occupied structure than an unoccupied structure. But in that case, because it did almost or arguably fit more into the definition of an occupied structure, the court said that the state had not presented sufficient evidence to support a conviction for breaking into an unoccupied structure for breaking and entering, and then overturned that gentleman's case. So by saying that if you have a structure under the first part of the statute, and if any of the 4 additional circumstances are present to make it an occupied structure, that's what it is. If none of them exist, it's an unoccupied structure. That solves the problem and fills the vacuum that Mr. Fausenbacher's case has opened up. So that is essentially what the state is asking the court to do today. And unless there are any other questions from the justices, I would reserve the balance of my time.
Mr. Armstrong.
Thank you, Chief Justice O'Connor. May it please the court, counsel, my name is James Armstrong. I, along with Mr. Emmett Robinson, are representing the appellee Andrew Fausenbacher. The state is asking this court to redefine something the legislature has had many years to define and has chosen intentionally not to. The state has pointed out numerous times in their brief and here today where section 2909.01 was used to define other statutes. The legislature specifically did not include 2911.13, the breaking and entering statute, in this. The Carroll Court noticed this and focused on the common law definition of burglary to begin their analysis, in that case, some 40 years ago. And in the 4 decades that have gone since then, the legislature has not felt the need to take the time to define this as the state has asked. I believe the General Assembly's position was intentional. And the reason is because you can have the exact item, because in this case is an example of it's not only what it is, but where it is. And you can have a travel trailer, a camper, in a driveway and a campground, in which it would be analogous to common law burglary, which was the invasion of home invasion of property originally at night. However, if you take that location and you put the travel trailer or camper and it's in a junkyard, or it's in a distant storage unit, as in the case here, it's hard to analogize that to the same thing as a travel trailer in a driveway. And as
help me understand, under your definition, what would be an unoccupied structure? Give me an example.
An unoccupied structure is a travel trailer in a junkyard. It would be a travel trailer in a storage unit that's winterized in this case. An example of an unoccupied structure that would come in under the breaking and entering statute using the item here. It could be in a driveway, in a campground. It could even be in a grocery store parking lot, for that matter, someplace.
Why would that be an unoccupied structure?
It would be a structure. I'm sorry.
So what's the difference between, if it was in a campground, it'd be different than if it was in the storage unit?
Yes, under the statute, Your Honor, an unoccupied structure if you go, I don't think it's an accident, Your Honor, that it was put under the burglary sections.
Okay, just give me an example of what an unoccupied structure would be, because I don't understand how your definition. I don't understand what would be unoccupied structure under your definition. So just give me an example.
An RV in a person's driveway.
Why wouldn't that be? Well, that would be an occupied structure, right?
No, it would be unoccupied if it was likely to be occupied. If it was vacant, it was just parked there.
Well, what would be the difference between that structure and this structure if it's not likely to be occupied?
Well, there's more of a chance if we go back to the foundation of common law burglary.
I'm interested in the statutory language. So under the statute, you're telling me that if it was parked in a driveway, rather than a storage unit, that would make the difference, and it would be an unoccupied structure?
Under the statute for breaking and entering, yes, sir.
Why?
Because it's more likely that you would have somebody in the at the time. And
if it's likely that there could be someone there at the time, then it would be an occupied structure, right? It's maintained as a permanent or temporary dwelling, even though it's temporarily unoccupied.
Well, I think
so. That would be an occupied structure. So what would be an unoccupied structure?
An unoccupied structure. With respect, Your Honor, I believe that would be considered an unoccupied structure, Your Honor, because it would not be occupied and it'd be on property.
But but why wouldn't it be? It's adapted for overnight accommodation, whether or not any person is actually present. That would be an occupied structure. So that's not an unoccupied structure. So what would be an unoccupied structure?
I would say I'd say a travel trailer in a junkyard. Travel trailer in a place where it's not likely to be used for its intended purpose, as we had here in this case.
Isn't that exactly what we have here? That's what we have in this case, right? Something that's not likely to be used. So
if we have
unoccupied structure has to mean something under the statute. So,
but Your Honor, if you have a situation where the facts matter with regard to what's an unoccupied structure and what is not, it gives the individual courts the
I assume that when the legislature created the category of unoccupied structure, they assumed that there were some things that actually fit in that category. So would like you to help me identify something that under your definition would fit in that category.
What would fit in an unoccupied structure? Your Honor, I will concede that's one of the dilemmas with the legislature not defining what is an unoccupied structure.
So everything's either an occupied structure or not a structure. Is that kind of how you read the statute?
Well, Your Honor,
it's just a null set. There's nothing in that category. No one can be charged with that crime.
Your Honor, no, that's not what I'm saying. But I think you have to have the item in reasonable ability to be used.
But if it's in a reasonable ability to use, then it falls in the category of occupied structure. So that's kind of the rub. I mean, if a time is especially adapted for the overnight accommodation of any person, whether or not any person is actually present. So if it's reasonably capable of being used, then it's an occupied structure. So what's unoccupied?
Mr. Armstrong, would it be related to the permanency of the status of the item? In other words, it's permanently abandoned, no longer useful for what it might have once been useful for? Would that be something to take into consideration?
Yes, Your Honor, I think that would be important to take into consideration, along with where the specific item is located. I think it's very important when we look to interpret the facts and the statute. I really think it's important to go back to the common law burglary, because that's where the statute is located.
Well, but doesn't that counsel for this being an unoccupied structure, because it's located in a storage unit, so it's not likely to be used. It's a structure. It doesn't fall in the definition of occupied structure. If that's the only distinction is where it's located, then it seems like you have a tough argument to make here.
But Your Honor, I would disagree with you, because it wasn't in a position to be used.
Right. So it's not an occupied structure.
Well, but Your Honor, if it's not in a position to be used for its intended purpose, then
that would seem to say it's not an occupied structure. So,
well, I would disagree with Your Honor, simply for the simple reason is that if we do that, we're going away from the foundation of the statute itself. And there had to be a reason that they put this under the burglary section and not more synonymous with vandalism. And that would be the personal property of somebody, and also the fact that there would have to be some sort of invasion and some sort of violation of that expectation of privacy that we have in the burglary statutes, and have going back to the common law and William Blackstone's commentaries on the law of England, written some 250 years ago. That's where the important part of this this case is located, and with regard to the definition. And I submit it's the reason why the legislature intentionally didn't define it, and the reason why the Carroll Court also didn't specifically define it, because something, as the Carroll Court stated, a unanimous court, by the way, indicated that in certain circumstances that VW bus could have come in under the statute, but it wasn't in a configuration for purposes of overnight stay. And that's what was synonymous about this case. And that's the reason why facts matter, and why I submit that nobody wanted to do a definition, because just the little change in facts, namely not only what it is, but where it is why it's so important to leave that flexibility in the statute, and why it's going to be hard to come up with a specific definition that doesn't create injustice create maybe justice in one circumstance, but then creates an injustice in another that goes well beyond the scope of the statute, the legislature's intent, which in 4 decades haven't thought to change that, and they're presumed to have known this court's decisions. And then to provide the ability of someone to have a general idea what the law is, Your Honor. And one of the reasons I think that we cite 290104 is because of the ambiguity in the statute, and the reason why that needs to be read in favor of the accused and not in favor of the government, as was done in the Carroll case as well. And although this court 4 decades ago notified the legislature of this ambiguity, the legislature did not take it upon themselves to define it. And this court has had a history of not creating definitions for the legislature when they themselves chose not to have one. And that's the circumstances that we find ourselves in today, where the state is asking this court essentially to create a definition for the legislature. To have the legislature, we talk about occupied structure, Your Honor, but nowhere in 291113 does it reference that the way to determine unoccupied structure is to look at 2909.01. And where it does specifically mention it in other places. Now, I do know the Carroll Court did reference that statute in trying to come up with a definition with regard to the travel trailer. But as they did and determined unanimously that the Volkswagen bus is not would not come under the unoccupied structure in 291113, they did indicate that it could be configured for overnight stay, and then it would have. As such, I I believe that the court has actually provided guidance for other courts down the line in the fact that Carroll for 40 years has still stood, and we've been able to use that definition and the analysis in Carroll as a way to decipher the various circumstances. The state themselves referenced the Pierce case, which was, I believe, an arson case where the RV itself was parked in the driveway of the home in question. Again, I can't stress enough that it's not only what it is, but where it is. That's what's important, and how it's placed, and the need to focus not only on that aspect, but also if there was ambiguity in the law, that ambiguity must be interpreted in a way most beneficial to the accused. I realize that at times these type of cases may cause some issues because of the fact that there is no definition of unoccupied structure, but it does allow the individual facts to determine whether or not 2911.13 applies with regard to the unoccupied structure language of that statute. And I see my time is slowly running out. I don't really have any more comments to make with regard to this. I simply ask this court to affirm the decision of the 9th District for their logical and thoughtful process in interpreting the statute regarding the facts of this case.
Thank you. Thank you, Mr. Armstrong. Ms. Corrigan, you have reserved about 4.5 minutes.
Thank you, Your Honor. Just a few points. First of all, the state is not asking this court to redefine or even to amend or do anything with 2909.001C. We're just asking for this court to proscribe an analysis framework for the statute. Second of all, I'd like to get to the point that Justice DeWine brought up about the null set. That is actually the problem with the 9th District's analysis of this question, is that it basically said if it's not an occupied structure, it's nothing that can be protected. And that creates the null set that Justice DeWine was asking about. And that's why we're asking for this court to give us a solid framework like the one we've asked for today, so that we don't have that null set.
So is there any circumstance under which a travel trailer would not be an unoccupied structure or an occupied structure? I mean, if we look at the facts of a particular case, would they ever be different than what we have here in your view?
Well, I think I have to say this first, is that the way that Mr. Fausenbacher wants to look at this problem essentially creates the Schrodinger's felony, for lack of a better term. It would be nothing. Factually, to make a camper trailer an occupied structure, it could be, these would be facts that would tend to get to proving that it would be an occupied structure, which is a kind of a separate question as to whether it's a structure in the first place.
Well, let's take Mr. Armstrong's example of what if we had this same travel trailer, but it's in a junkyard. It's not being stored, no winterization, it's just in a junkyard. Would that fit the definition, do you think, of unoccupied structure? So it would still apply as in this case?
Yes. And the state's argument is, though, that even though it's unoccupied, the legislature, by creating the breaking and entering statute and making a difference between trespassing in an occupied structure versus trespassing in an unoccupied structure, still intended to protect that trailer, even though it's in a junkyard. And even though nobody is reasonably anticipated to be camping in it at the time.
Does that make sense? That we would protect a trailer because it's it at one point could have been an occupied structure as opposed to unoccupied, but it's sitting in a junkyard with obviously no intended use for occupation.
Well, at that point when it's in a junkyard, it still has value as property. And so the items within it, the trailer itself still has value that the legislature intends to protect. If it didn't, otherwise the legislature wouldn't have listed trailers, even tents, trucks, railroad cars, aircraft, watercraft, among the definitions of structures that it intends to protect. So I hope that's...
Wouldn't counsel, given Justice French's example where it's in a junkyard, if it's clearly unusable, if it cannot be salvaged, rehabilitated, occupied, you're still saying that it would fall under the statute?
Yes, ma'am.
Let me add on to that. How would a thief not know that the trailer was occupied by the owner of the junkyard if it's fully intact? Right? That
would be a question for that jury. And
right.
Unfortunately, I have 7 seconds left on my clock.
And it'd be one thing if the structure was ripped apart and clearly had become something no longer a structure, right?
It could become no longer a structure. And at that point, it would be miscellaneous property that the thief would be taking from the junkyard. But it would no longer fit the breaking and entering statute because it would no longer be one of those things that's listed in 290901C that we can say is a structure for the purposes of the code. And I hope that that helps explain. And I know I've exhausted my time, and so I thank the court very much and ask you to reverse the 9th District Court of Appeals decision. Thank you.
Thank you. Thank you both. We'll take the matter under advisement and you'll be notified of our decision.
Aaron.
Thank you.
Our second case this morning is 2020-467, the Disciplinary Council versus Joan Jacob Thomas. For the respondent, Mr. Alkire.
Thank you, Your Honor. May it please the court, Madam Chief Justice, justices of the court, counsel for Relator and Ms. Thomas. Indeed, it's my pleasure to appear before you representing Ms. Thomas. I must say, however, it is the first time I have done this in a disciplinary matter where the board adopted the dissenting panel members' view of the case when the majority of the panel recommended that the entire matter be dismissed. Indeed, despite this curious posture, even the board and the dissenting member adopted the findings of fact through paragraph 66 of the board report. So there's very little argument about what the clear and convincing evidence was or was not in this matter, as there is truly unanimity. Importantly, the panel unanimously recommended the dismissal of the second branch of count 1, which was the 8.4D allegation, and the board adopted that recommendation. This recommendation came after the mid-hearing unanimous dismissal of count 2 of the complaint, which alleged that my client had made false statements.
Paragraph 50 of the complaint that you said everybody agreed to talks about the letter itself. It says, "Dear Ms. Barnes, I'm sending this correspondence to you since it is an ex parte communication." Isn't that an admission against interest by your client?
Not at all. It's simply the characterization the judge gave it at the brown bag luncheon as the sentence went on, and I do not wish to expose the judge to a situation wherein she feels the need to recuse herself from this matter.
But in fact, your client wanted the judge to do something, to create a investigation or a guardian ad litem or both.
With all due respect, Your Honor, what my client wanted to happen was what the protocol the judge established set up, which was let the staff attorney look at this and see whether the letter ought to be returned or whether it ought to be acted upon, but nonetheless, only according to the protocol, which involved, most importantly, the knowledge by my client that the lawyer in the matter would be given a copy of that letter. And that's what the protocol was, as admitted during the hearing and as explained in the brown bag lunch on May 2nd.
Counsel, on paragraph 54 of the agreed facts. Okay, question. Okay, you knew it was the judge that would have to issue those orders, correct? Answer, the judge would have to issue those orders, correct? Your client wanted the judge to do something.
My client wanted the judge to pursue the protocol that she laid out in the luncheon, which created the ambiguity which brings us before you and distinguishes this matter from any case that's been cited to this court.
Then what about the Stafford case?
The Stafford case has nothing to do with this. It's not even close. And it provides no authority which in any way addresses the circumstances that this matter presents this court. This is a matter where during a brown bag lunch and a discussion with lawyers, the judge happens to volunteer after about the first 5 minutes that in her courtroom, what she would want would be a letter sent to her staff attorney outlining the concerns. And then if the staff attorney didn't throw it away, or if the staff attorney didn't return it, she would give a copy to the other side and have a hearing, which she did on July 31st, at which time she gave the one and only lawyer involved in the case, it was a non-adversarial matter, the opportunity to ask the court to not do anything, which he chose not to do at the hearing or for the 7 days that followed after the hearing before the court made any order whatsoever.
Before that, why would your client not give Bartos the letter?
My client offered to let Bartos look at the letter, and the reason she didn't is because Donna Veely was a vindictive woman that she was afraid of, and she forecasted in the letter, Joint Exhibit 15, the top paragraph on the last page, exactly what she figured Ms. Veely would do once she got a copy of the letter. My client thought, I'm not going to give the letter at this time. I'll let Mr. Bartos see it. And if the staff attorney decides to return it or throw it away, no harm, no foul, nothing will happen. However, if the staff attorney does pursue it, it's going to be given to Mr. Bartos, and he's going to have an opportunity to do whatever he wants to oppose any thought that there would be a GAL appointed, God forbid, for this minor 6-year-old with special needs or an investigation by FCS, the one and only type custody proceeding where those safeguards don't exist.
Let's look at paragraph 60, your client's testimony, where she says, look, David, the judge made it clear you will get a copy if there's any action taken on the letter because she's transparent in that way.
Exactly.
She wanted the judge to act, and she sent an ex parte communication so the judge would act.
No, she sent a letter to the staff attorney that she was requested to send a letter to. The court admitted
according to the judge's testimony, she didn't want people sending letters, and she was telling about her process in which her staff person would read the letters first so she wouldn't get it, and she didn't want to get letters.
And the panel didn't believe the judge's testimony. It's clear from its report that the panel felt that the evidence was less than clear and convincing as it relates to what happened at the luncheon. My client was consistent from the very first response she made to disciplinary counsel through the time of the hearing, and knowing that the judge had inconsistent testimony that the panel rejected, by the way,
And why did
it wasn't clear and convincing.
why did your
And
client?
I don't mean to be
No,
disrespectful.
that's okay. I'm sorry. Why did your client not contact Children's Services?
Because she knew without a specific incident, Children's Services would do nothing, and she couldn't make up a specific incident. She wouldn't do that. She talked to Kim Alzier, the GAL, beforehand to decide and learn that that would be a roadblock that couldn't be overcome because there was no specific incident. She discussed that possibility not only with Kim Alzier, but also with the lawyers at the Brown Bag Luncheon. And by the way, Your Honor, Chief Justice O'Connor, I failed to reserve and would like to 3 minutes for my rebuttal, and I understand I'm 7 minutes and 19 seconds into my argument.
And additionally, paragraph 61, which all the panel agreed upon, Judge Glass was referring the matter to the Family Court Services based upon the information Barnes gave her from the information in the letter your client sent.
That's true, Your Honor, and that was 7 days after Mr. Bartos was given an opportunity to alter that course that he chose not to. So there's no communication here that caused any issue whatsoever that would lead to the conclusion that there was not due process. There was clearly an opportunity. You know, the judge's protocol, when it's followed through, doesn't violate the rule. However, if you find in this case that that rule has been violated, it was violated by Ms. Barnes and the judge too. And I don't think that's a result that ought to obtain here by any stretch of the imagination. What Joan did was sincerely, as the panel unanimously found, care about a special needs child where the mechanism in the law didn't exist to give her a voice. And she understands how this procedure that created the ambiguities that resulted in her being before this court today has caused problems, and she knows that she will never do something like this again. The public is.
I thought her testimony was she was happy she did it and she would do it again.
She didn't say she was happy. She said she'd go to a bailiff and she'd ask the bailiff what to do. And if the bailiff said, just like any other bailiff who would look at this and say, don't write a letter, she wouldn't write a letter. That's the testimony. That's clear.
So counsel, you're telling me that a lawyer would ask direction of a bailiff who's presumably not a lawyer, not a magistrate, not a judge, would ask advice on an ethics question from a bailiff?
Not an ethics question. She would ask a bailiff, look, I have concerns about a matter that involve a minor child. What would you suggest I do in connection with such a matter if it's pending?
What about Children's Services or the entity that has the custody of the child?
Well, because first of all, Human Services wouldn't handle it unless there's a specific incident to talk about. There wasn't any specific incident. And by the way, the bullet points in the letter were all agreed on by the panel at the hearing and relator that they were accurate. There was no challenge to their accuracy in this matter. None.
Mr. Alkire, let me ask this. A professional conduct rule 3.5A3 says that a lawyer shall not communicate ex parte with a judicial officer or other official as to the merits of the case.
Right.
Does that have any meaning that clearly puts this case in that realm, or is it questionable what the case means?
Well, the case is this transfer of custody proceeding. The judicial officer is not the person that the letter was written to, and this was a non-adversarial matter where Joan did not take sides on anybody's behalf, questioned the entire arrangement. questioned the Dunsings being involved in it, and questioned Donna Veely being involved. So she took no side. It wasn't an adversary situation, and it's truly not an ex parte communication.
But is this clear that this rule applies to all cases that are proceeding, or only a case where the lawyer is representative in that case, either as a client or as an attorney?
Well, it applies to advocates under Chapter 3, and it applies to adversarial proceedings, of which this was not one. My time is up, and I'd like to reserve the rest for my rebuttal.
Okay, thank you.
Mr. Kanai? You'll have to unmute yourself. There you go.
Thank you. Thank you, Madam Chief Justice. May it please the court. The respondent's argument in this case seems to largely turn on the existence of a process or a protocol that he claims was an attempt to justify the actions of Ms. Thomas, but ultimately they don't. And we would submit that the disciplinary counsel v. Stafford is directly irrelevant to this case. In that case, the court said that the customary use of a particular procedure cannot condone the unethical exploitation of that procedure. And that's precisely what happened here. Both the judge and the staff attorney in this case testified that the purpose of the existence of this particular protocol is to prevent our ex parte communications from tainting a proceeding. Ms. Thomas exploited that procedure, and she understood exactly what she was doing. In both her sworn testimony and the letter, she indicated that she had no intent whatsoever for the judge to ever be aware of the specific contents of the allegations that she was making, but somehow she hoped that the judge would issue an order both appointing a guardian ad litem and family court services investigation. Now, those two statements are facially contradictory unless, and Ms. Thomas testified to this, unless she believed that Amy Brown was empowered by the court to act on cases. And she did. She clearly believed that. She knew that Amy Brown was serving in an official capacity in this case, Amy Barnes was serving in that capacity, and that Ms. Barnes had been empowered by the court to both receive communications related to specific proceedings, and if those issues were significant, Ms. Barnes could in fact act on them. Her own testimony indicated that, and so it's clear that her desire from the beginning here was to get the court to sidestep the parties and then to issue an order. Most of the justifications that she's raised since then are nothing more than post hoc rationalizations of that initial decision. And I want to be clear that regardless of what Ms. Thomas's intentions were, the question here today is whether the burden of proof was met to show a 3.5 violation, and it was. Each and every element that's required to be proved in a 3.5 violation was proved here. Ms. Thomas is an attorney. She communicated directly with an official serving in a capacity in the proceedings, and she did so without informing the parties. That is by itself enough of a justification. Further, Ms. Thomas's arguments as they relate to somehow the staff attorney not being an official because she doesn't carry the title of judge or magistrate, as Commissioner Dingwell noted, that would create an immense loophole in the rule. It would encourage a chaotic free-for-all that would ultimately have litigants communicating with entire bodies of court staff. As long as they avoided specific titled parties, they would be able to do so in an attempt to influence proceedings before the court.
Let's take a situation where a lawyer feels an obligation to be protective, whether it's of a child or a party. They're not involved in the case, but they have a genuine concern for a matter that's before the court in another case. How should that lawyer go about it?
Well, in this case, Justice French, the only thing Ms. Thomas needed to do was to send the letter that she sent and send it to the parties. Had she done that minimal requirement, we wouldn't be here on a 3.5 violation today. It wouldn't be an ex parte communication. It was Ms. Thomas's choice not to send the letter to the parties. And that choice, I know that we've talked a lot about best interest of children, but that choice was fundamentally a selfish choice. She made that decision, as counsel has said, because she didn't want to incur the wrath of one of the parties.
Well, let's say if in my hypothetical situation, you said you notify the parties. Should the lawyer also notify the judge?
I'm assuming yes. If she's going to communicate, ultimately whether she communicates with the judge or with another official who has the ability to affect the proceedings, those are fungible parties for the purpose of the ex parte rule. So in your hypothetical, I would say it wouldn't matter whether she communicated directly with a staff attorney, a magistrate, or a judge. The burden on her is to communicate with the parties. And had she done that, we wouldn't be here today.
What weight do you give that she was at this brown bag luncheon and heard what the judge had to say about this process that the judge's office has set up to get various communications? And I thought the judge did a good job of explaining in her testimony, look, sometimes we get letters from DYS or, from somebody in DYS. I mean, there are times when you've got these pieces of communication coming in. So what weight do you give that this lawyer sat in the luncheon and heard about this process and thought she was following it?
Well, the one thing I would say is that the ethical rules are self-executing. It's the attorney's obligation to follow them, and they can't be excused by the conduct of someone else. In this case, if the protocol was in violation of the ethics rule, it doesn't forgive the attorney involved. So the ethics rules only have two exceptions in this particular case, and that is if it's under sanction of law or by court order. Neither of those occurred here. However, I would point out that it's fairly clear from all of the testimony that the protocol was not designed or explained as a way to circumvent the ethical rules. I think that was Ms. Thomas's interpretation because that was ultimately what she wanted to do. But
did the judge violate the ethics rules here?
No, I don't believe so, Your Honor, because the judge's obligation is not to consider an ex parte communication if it comes in.
And clearly the judge got some information in some form, or there wouldn't have been an additional investigation done. So, I think whether it's direct or indirect, there's clearly some communication with the judge. So,
sure, that information comes by way of Annie Barnes, the staff attorney, who made a recommendation to the judge that an investigation was appropriate in her mind.
But that's still a communication. That's still a communication to the judge. I mean, yeah. The recommendation came from somewhere. I mean, sure. I can't have people calling my law clerks and giving recommendations how I should write cases.
Absolutely not, Your Honor. I agree with you. However, the question is that once the damage is done, once Ms. Thomas has committed the ex parte violation, what is the judge supposed to do? Under the ethics rule, the judge is supposed to notify the parties and give them an opportunity to respond. That's the cure for the judicial remedy that a judge can take once an ex parte communication has been accomplished by an attorney. And that's what happened in this case. So I don't believe that she violated the ethics rule by considering it because the rules actually require her to do that. She notified the parties and gave them an opportunity to come before her. So,
well, counsel, at that brown bag lunch, was there the representation? Well, obviously there was a representation that the judge claims that she has a channel, for communication. But was it also mentioned at the time? So just send things directly and don't have any, duplication or a duplicate letter sent to opposing counsel. There was no admonition to do that, was there? To not inform opposing counsel?
No, there was no admonition to do that. Ms. Thomas says in her testimony that she understood that if a decision were made, that action were taken, the counsel would be informed at that time. But that is completely different than an affirmative admonition suggesting that a counsel not be informed. There's no point in any part of this record that suggests that anyone informed Ms. Thomas that it was appropriate to simply cut counsel out or to cut either of the parties in this case out. That was a decision she made. And again, as I said, the reason she made that in this case is for the selfish reason that she simply did not want to have Ms. Veely mad at her. And that is a violation of the ethics rules. The ethics rules do not give an attorney the decision to make an ex parte communication merely because there might be some consequence if they make that communication. The rules say you won't make those communications. They're improper from the get-go. And so that's why we would say that essentially we have met all of the burden of proof for this. There was an official who had the opportunity to influence the outcome of the proceedings. The parties clearly were not notified. And ultimately, those are sufficient evidence or evidentiary findings to show that 3.5 violation occurred. The existence of the protocol in this case, as I said, under Disciplinary Counsel versus Stafford, The existence of the protocol does not justify the unethical exploitation of that protocol, and that's what happened here. Ms. Thomas made a series of allegations suggesting as best she could child abuse and neglect in the hope that Amy Barnes would feel morally compelled to act upon these facts. And she knew that Ms. Barnes was in fact empowered to do so. That's exactly what happened, and this is the type of breakdown that the rules are designed to prevent. Unless there are any further questions, Your Honors, I would yield the remainder of my time.
Thank you. Mr. Alkire?
Thank you, Your Honor. Let me make a few quick points. I would like the court to consider the June 4th email that came in 2019. I think it demonstrates that the court, Ms. Barnes and Ms. Price, the court's former staff attorney, didn't feel that communications with staff attorneys were at all ex parte. And that's the uniform testimony from all three of those witnesses about what is clearly an ex parte communication that happened almost a little over 1 year after.
Counsel, does that matter whether the law clerks, thought it was a violation or an ex parte?
It sure does, because there's a requirement under our law in a discipline case to determine there was a willful violation. If these people don't think it's a violation, certainly Jones' testimony that she didn't think it was a violation shows that it's reasonable to conclude that this wasn't a willful violation at all, especially in light of Kim Alzier's testimony about Joan calling her right after the brown bag luncheon saying, look, there's an avenue here to help this child. And the panel unanimously found that the respondent felt she had a green light. And that's the reason why there's no willful violation here. Finally, indeed, it shouldn't elude everybody here that the judge never saw the letter. And the judge gave Mr. Bartos an opportunity to deal with that letter before she ever ruled that there ought to be an investigation or a GAL. And it also should not go unnoticed that the local rules in domestic relations court around the country, around the state that I cited, show that the people to whom ex parte communications shouldn't be made are judges and magistrates. Staff attorneys aren't in that list in those local rules. Again, fodder for the proof that there wasn't a willful violation here. Let me end with this. And this is in deference to Congressman John Lewis's recent death. He is quoted as saying, when you see something that is not right, not just, not fair, you have a moral obligation to say something, do something. Our children and their children will ask us, what did you do? What did you say? I beg this court to not punish Joan for following the protocol the judge gave her to allow the voice of an unrepresented special needs child to be heard. And I can't thank you all enough for your kind attention to our arguments today. Thank you.
Thanks. We'll take the matter under advisement. You'll be notified of our decision. Marshall, will you call a recess, or will you adjourn court, please?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.